Welcome, everyone, and thank you for joining our webinar. My name is Gonzalo Mon. I'm a partner in the advertising group, and I help clients with a variety of advertising issues, including ways to get out of these lawsuits that we're talking about. And I'm joined by my colleague, Jeff Costello, who's a partner in the litigation group. Jeff represents clients in a number of class actions, including some of the ones that we're going to talk about today. We've just got 30 minutes and a lot of content, so we're going to get started. By way of background, when we think about email marketing, we typically start with CAN-SPAM at the federal level. It's the law that governs email marketing. It's primarily enforced by the FTC. And importantly, it does not have a private right of action for consumers, which is why we don't see class actions in the CAN-SPAM space. Also importantly, CAN-SPAM preempts state laws except to the extent that they prohibit falsity or deception. There are about 30 states that do have email marketing laws, but because they are largely preempted and because compliance with CAN-SPAM usually means you're complying with those state laws, really almost no one has paid attention to those state laws until just about 12 months ago. The law that started gathering everyone's attention 12 months ago is Washington's Commercial Email Marketing Act. And in relevant part, that law says that you can't send a commercial email to an address that the sender knows or has reason to know is held by a Washington resident and that contains false or misleading information in the subject line. Importantly, this statute has statutory damages that are currently $500 per email, without having to prove any damages, which is helpful for plaintiffs since there typically are no damages here. And because a violation of CEMA is a violation of Washington's Consumer Protection Act, these damages can be trebled. And if you see towards the bottom there, the impact of just one allegedly misleading email sent to 100,000 Washington residents can lead to liability of $50 million or more. And most of the cases that we're looking at aren't involving one email. There are a number of emails that are alleged to be misleading. So these numbers can add up significantly. The case that brought this to everyone's attention came out just about a year ago. It was Brown versus Old Navy. Plaintiffs argued that Old Navy had violated CEMA, and the complaint included 91 subject lines, some of which you'll see on the screen there. So for example, at the bottom, Old Navy advertised $12 women compression leggings, today only. And then the next day, $12 compression leggings. November 29th, final hours of 50% off and $7 pajamas. The next day, no joke, it's Cyber Tuesday, 50% off has been extended. Or the email after that, $12.50 jeans, today only. Next day, $12.50 jeans. And that pattern repeated itself. There were other emails, but the general predominant fact pattern was a pair of emails, one of which would say a sale was about to end or it was today only, and then the sale continued the next day. There was a question about what type of falsity CEMA prohibits. And Old Navy had argued, and there's a good reason to argue this based on some of the legislative history, that the law was intended to prevent deception of email subject lines that suggested an email was not commercial when it really was. The Washington Supreme Court, though, read it a lot more broadly, and they said that a company violates the law even if the false or misleading information doesn't deceive consumers about the nature of the email. So more specifically, they said that CEMA protects consumers by requiring that commercial emails communicate honestly about the terms of a promotion in the subject line. After this decision came out, the world changed quite a bit, and I'll let Jeff talk about that.
The blood was in the water immediately when this decision went live. Lawsuits that had never been filed under this statute started to be filed very quickly. And today we're up to more than 100 of these lawsuits. Today, if you are the target of a lawsuit, you might know that if you're following social media from any of the plaintiff's class action firms. They regularly advertise for many, many companies with advertisements that look exactly like this. And these are designed to catch plaintiffs to create claims, and they do. And with these types of advertisements, the lawsuits continue to be filed.
And here we see on the left, for example, there's an ad that's targeting a specific company. So we are seeing some of those. And on the right, you'll see an example that's a little bit more open-ended, like, hey, have you gotten an email suggesting a sales extended? On the one on the right, you'll see if you've got these, you might be entitled to up to $500 per email, which I would argue is false advertising because the consumers are not getting that money. It's all going to the plaintiff's attorneys. So in these 100 or more cases, we've seen a number of retailers challenge CEMA. And the main theories we've seen so far is that CEMA is preempted by a CAN spam or that it violates the Dormant Commerce Clause. The preemption argument, a number of courts have ruled on that one already, and they said CAN spam preempts except to the extent that state laws talk about misleading or deceptive subject lines, and that's what's at the heart of these cases. So that argument didn't work. We don't have to go into the Dormant Commerce Clause argument, but so far courts have rejected that. There is an interesting pending motion in one of these cases in which a retailer is arguing that CEMA violates the Due Process Clause, in part because there's a potential for really excessive and burdensome penalties that bear no relation to the harm, and really no harm in these cases. But that's still pending. So for now, the law is still in the books and we need to worry about it. One of the groups that started worrying about this right away when they started seeing this pattern was the Washington Retail Association. They acted pretty quickly and tried to get the law amended. The proposed amendment would have been very helpful and I think would have helped to stem the tide of some of these lawsuits. What ultimately passed, and it passed in March, was I would say a more watered down version. It makes two key changes. The first is that damages are reduced from $500 per message to $100 per message, or actual damages, which again, we know don't exist. And then a plaintiff has to prove that the sender knew or should have known that a subject line was misleading. The changes become effective on June 11th, so just in a few weeks. Is this going to stem the tide of the lawsuits? No, I think the plaintiffs are still going to have the same incentive. But later on down the line, after the motion to dismiss, I think it does give retailers things to argue about, both in terms of the damages and did the retailer know or should the retailer have known that a subject line was false and misleading. In some of these cases, that's really not clear.
It's also important to note that the amendment is not retroactive. So if you are currently in a CEMA case in Washington State or Washington in federal court in Washington, you are still under the purview of the old statute.
Yeah. And do you want to talk about the last bullet too?
Yeah, I think it's important to note that knowledge requirement is still in the statute. So the sender has to know or has to have reason to know that they are sending an email to a Washington resident, which is extremely difficult from a technological standpoint. But also the knowledge goes further and it requires that the sender know that the email subject line, and we're only talking about subject lines, contains false or misleading information.
By the way, the Washington Retail Association explained that this year Washington had a 60-day legislative calendar, so there was only so much they can get done. They hope to come back to this next year and come up with a more permanent solution. So it all started in Washington, but we have seen lawsuits in other states. more than 50 in California, and California has a few quirks that we will talk about. We've started to see some in Maryland, Florida, and just recently a couple other states popping up as well. The themes are similar to the ones we've talked about. The low-hanging fruit is the sales being extended. So sales going to end tonight, and then it continues the next day. Or the false sense of urgency. Hurry, act now. When in reality, people don't have to hurry because the sale's going to be live. Stretching a little bit further, we have also seen plaintiffs challenge reference pricing and free offers in these CEMA lawsuits. And we'll take a look at both of those individually. When we talk about reference pricing, we're really talking about a former price when you say that something is on sale compared to a former price. The FTC has guidance in this area saying that a former price has to be the actual price at which you offered something to the public on a regular basis for a reasonably substantial period of time. Approximately 20 states have laws that deal with pricing. Some are specific. For example, we see some states say that if you're going to claim something is on sale, it had to be at the regular price for at least 28 days out of a 90-day period. But many of these statutes are ambiguous. They'll talk about prevailing price or reasonably substantial period of time. And it's worth noting that even states without these statutes can pose risks because plaintiffs can argue that a sale will violate general deceptive advertising principles. So let's take a look at some examples. This is a pending case in Washington. The plaintiffs challenged a number of subject lines from Nordstrom, including the one you see there, boots up to 65% off. And the complaint says that in reality, the percentage off statements were calculated from fictitious prices that Nordstrom never or almost never offered the products. This case is still pending, so we don't have an answer. But recently, a couple of weeks ago, there was a decision in a case that does not involve CEMA that I think may provide some hope. That involved Aeropostale. You'll see here an ad for $6 leggings and $12.50 is crossed out. Here, the plaintiffs argued that the regular price was false and deceptive because unbeknownst to the plaintiff, Aeropostale had almost never offered the leggings at $12.50. So this went to the Washington Supreme Court, and they were asked whether this is a sufficient injury under their Consumer Protection Act. The Supreme Court said no. A consumer doesn't suffer an injury when she purchases and gets and keeps a product that she wanted just because the seller may have misrepresented the product's price history. The court went on to say the complaint shows disappointed expectations, but those expectations aren't enough to support a claim. So again, not a CEMA case, but I think this provides some good arguments for the pending CEMA cases or the ones that are still on the horizon. In terms of free offers, again, the FTC has some guides in this area. They state, amongst other things, that the term free should be used to indicate that a recipient is not going to pay any money for the item that you're calling free, and that they're not going to pay anything else for the regular price of the items they have to pay. So you can't inflate those prices to recoup. But perhaps more importantly for what we're looking at today is this idea that any terms related to the free offer have to be clearly and conspicuously disclosed at the outset of the offer. And if you look further in the free guides, they clarify that something in a footnote is not going to be deemed at the outset. So we have seen this guidance and analogous state guidance incorporated into some recent cases, including this complaint against Bloomingdale's in Maryland. You'll see there the subject line has Sicily, Paris, choose your free 5-piece set. According to the complaint, the subject line implies that a free gift is being provided unconditionally at no cost to the recipient. So they're arguing consumers see this and they think that they get a gift just by opening the email. Is that really what consumers think? Probably not. Maybe the ones that think they're going to inherit wealth from a Nigerian prince. But I think most people aren't thinking that, right? They know that there's something in the body of the email that's going to explain the requirements. And luckily, the District Court of Maryland agreed and granted a motion to dismiss. This is an important quote. Commercial email with a promotional subject line isn't required to include every conceivable limitation on an offer, and the absence of the limitations alone is not enough to make a subject line false or misleading. So it's a good decision. It's a common sense answer. The subject line of an email does not have room for all the terms and conditions you would have associated with a free offer. So we saw this and we were in a good mood because common sense was prevailing. And then not long after that, we saw a decision in this case. This one involves Ulta. The subject line, as you'll see, is very similar. Free 8-piece prep and set gift inside, which is really same sort of thing we saw here, right? A free set. Here, the complaint, something very similar. The subject implies that the gift is being provided unconditionally at no cost, simply by opening the email. Again, I don't think that's realistic. I don't think people think that. Unlike the Maryland court, though, here, the U.S. District Court for the Eastern District of Washington allowed the case to proceed. For the purposes of this motion, the court accepts as true that the free gift and percentage discount email subject lines are false or misleading because of the limitations in the body of the email. It's a bad decision. It's surprising, again, because emails routinely provide details that are not available in the subject line, but it's something to be aware of when you are faced with one of these cases. California's anti-spam law is a little different. It has some quirks, one of which I think is going to be helpful. You'll see there the law prohibits unauthorized use of third-party domains, falsified, misrepresented, forged header information, and the most important one, similar to what we see in Washington, subject lines that the sender knows are likely to mislead the recipients about material facts. Statutory damages are higher. They're $1,000 per email. But the important thing here is that in terms of the private right of action, only a recipient of an unsolicited commercial email can bring an action. So if a recipient has signed up to your email list, that provides a helpful defense. So for a lot of companies, California may be less of a risk. Still, there have been a number of cases. One firm in particular has filed over 50 of these. And part of what's unique here is that many of them target affiliate marketing. Here's one example. This is clearly an affiliate campaign, and the complaint says that this includes everything that people rightfully hate about can spam, and that may be correct. But you'll see that they look at some of the header information, which looks odd. On the from line, the email is ultraviolet blockchain gear column at richardwacker.com. Right, so that's arguably not reflecting the sender of the email. This case is still pending, but we just saw a decision in a complaint that was very similar. In this one, the Southern District of California granted the motion to dismiss on the first two counts, the unauthorized use of third-party domains and the falsified, misrepresented, or forged header information, which is a lot like what was in this email. The court said those are preempted by can spam. What survived, and this is consistent with what we've heard Washington courts say, is the claim on the subject line that the sender knew or should have known was likely to mislead recipients about material facts. So keep your eyes on these cases. Let's talk about a few tips to reduce risk, and hopefully some of these will be common sense. The answer, though, is ultimately going to depend on your risk tolerance. Jeff and I talked to a number of clients about these, and given the numbers at stake, we have many clients that are choosing more conservative approaches. For some, their business model really depends on creating this sense of urgency. So there are some companies that are taking, I would say, riskier approaches, but it's a conversation you want to have. So first, probably most obvious, you should avoid subject lines saying that a sale is going to end on a specific date if it's possible that you're going to extend it. I think it's a conversation with your marketing team. Yes, there are times where a sale gets extended and it wasn't planned, right? Maybe you didn't sell as much as you wanted to, you didn't hit goals, and you're going to extend it, or maybe something was so popular and people didn't get enough of it, and you extend it. In a lot of cases, though, I think marketing teams know or have an idea that something is likely to be extended. If you know your sale is going to end, it's perfectly fine to have an end date in your subject line or say today only. But if there's any realistic possibility it's going to extend, don't put that in the subject line. I think a harder question, and I know one Jeff and I are dealing with in some cases, is what if it's a similar sale? For example, we're looking at one client that had a sale on the website that ended as advertised, but then launched a similar sale that was an app exclusive or some variations on that flavor. No substantive decisions, so we can't tell you that's definitely a problem or it's not a problem. But if you are looking to avoid lawsuits as opposed to potential winning them, that's something you may want to think about. Pause before launching something that is similar. Along the same lines, anything that creates a false sense of urgency is a problem. A true sense of urgency, right, ends tonight. If it's going to end tonight, is fine. But the false hurry, act now could be a problem. Even things like this sale won't last long, I would argue may be fine. It's puffery. Nevertheless, we are seeing things like that being challenged, and until we have some decisions, I'd probably put that in the category of there is some risk associated with a subject line that says something as simple as this sale won't last long. Free gifts, it pains me to say this, but advertising a free gift in the subject line, even if the body of the email is very clear on the conditions, I think at least in Washington, that's a risk. In Maryland, it may not be, but most companies aren't segmenting emails based on state. So you're going to look at the most restrictive state. Where I have seen some clients do this, where I think there's less risk, might be free gift with purchase, right, in the subject line, and then of course below you've got the details, but the with purchase in the subject line, I think is probably a good deterrent to some of these lawsuits. Or references to BOGO, right? The B is buy, so it's clear that you've got to buy one to get one. Part of this exercise also requires you to look at your previous email. So it's not just what you're saying in this one, is that okay? But are you contradicting something that you may have said before? If so, then you run the risk that one of the pair might be deemed misleading. Second to last subject line, we're talking about reference pricing. It's a complicated issue, and there's been a lot of litigation over the years, but be careful claiming something is on sale if it hasn't been offered regularly at the price that you're referencing as a former price. And then the last bullet, I know, is one that's not helpful. It's vague, but we have to have this in here because plaintiffs keep evolving their theories, and we keep seeing new things that are challenged that, a month ago I would have said probably not a big risk, and then all of a sudden we see it challenged. It doesn't mean that the plaintiffs are going to win, but until we see some decisions here, I would put those in the category of you've got some risk here, and you've got to decide again: are you looking for subject lines that you can win if you're challenged, or are you looking for subject lines that are going to avoid that challenge in the first place? A California focus, opt-in. Again, the California statute, the private right of action, only applies to unsolicited commercial emails. So if you only send commercial emails to people who have opted in, I think that puts you in a much safer space. Of course, you should make sure you've got a good opt-in process, that you are maintaining the records of the opt-in. Obviously, you've got to give people an opportunity to unsubscribe. Honor those unsubscribes promptly, because if you send out an email and you haven't scrubbed against the unsubscribe list, that what a day ago could have been solicited, the next day could be deemed unsolicited. So make sure you're prompt about that. And then as we mentioned earlier, a lot of these cases deal with affiliate marketing. So when you're dealing with affiliates, you want at the outset to have strong contractual protections in your agreements. So you want to require compliance with laws. And you can do that with a general statement, or you can get granular about everything that CAN-SPAM requires from what's in the California law, from what's in the subject line, what you have in the header information and the from line. You probably want to address indemnification. It's not going to solve the problem, right? You're still going to get dragged into the suit, but it could help. Who's the affiliate marketer? Do they have the money to indemnify you? If not, consider whether you want some insurance as a requirement. And then guidance. You can provide guidance which may be the same as some of the guidance we're talking here, right? To make sure that they avoid some of these things in the subject lines that they send, because even if they sent it on your behalf, you could get in trouble there. So think about what guidance you may want to provide them. And then lastly, I would monitor performance. And you can build that into the contract. For example, they've got to send everything to you, even if you're not pre-approving. You have records and you can go back and look at it, or you can proactively audit things on the back end. Sign up for their emails, make sure that they are doing what you've told them to do. And if you have a problem, you have to move quickly and fix it. And I think, Jeff, unless you want to add anything else, we are at about time here. We packed in a lot of information and hope it's helpful. I don't know, Jeff, anything else?
Nope, I think you covered it all.
Well, if you guys have questions, you can put them in the chat and we can get to them later, or you have both of our email addresses out there. Hopefully this was valuable. This area is moving pretty quickly, but hopefully you've got some tips for how you can stay out of the shark infested waters. And if you do happen to fall into them, you know who to call to throw you the life raft. Thank you.
Yeah, thanks everybody.